Welcome to our spring Redesigning Legal. This series is a joint partnership between ILES and several ABA entities. ILES is the Institute for the Advancement of the American Legal System. And of course, we have our friends at the ABA also bringing you this event, the ABA Center for Innovation, the ABA Center for Professional Responsibility, and the ABA Standing Committee on Delivery of Legal Services. We have a great event for you today called Redesigning Legal, Cultivating an Oasis in Legal Deserts. And we've got an expert panel. Moderating our event today will be Danielle Hirsch, who's the Managing Director of Court Consulting at the National Center for State Courts. Also joining us today will be David Myshak, who's Deputy General Counsel at Kleinset PC, and Michelle Statz, who's the Associate Professor at the University of Minnesota Medical School and Law School. And we are very grateful to have all of our panelists with us here today. Just a few things before we get started. If you do have any questions of our panelists today, please use the question and answer function, which is enabled. We will try to answer those in real time as time allows. Additionally, this event is being recorded and will be available at a later date on both the Center for Innovation website as well as ILES' website for the Redesigning Legal series. And lastly, live transcription for this event is on as well. So I'm going to bring up our panelists now, starting with Danielle and Michelle and David, and turn it over to this great conversation. Danielle, thank you so much.
Thank you. Thank you to the ABA and ILES for having us. We're really excited to embark in this conversation. Like Joey said, we're going to have kind of an organic conversation. But we welcome your questions. So I'm going to try to track those in real time and we'll feed them in. So let's get started. So Joey introduced us at a very high level, but I'd love for us to start with explaining to one another why we think we were asked to talk about this topic. So let's start with David. What's your interest and experience in addressing legal deserts?
So my interest and experience is largely through the regulatory side of lawyers. My role within the ABA has been serving on its ethics committee, serving on its professionalism committee, doing all kinds of work within the Center for Professional Responsibility, but particularly in leading several efforts in terms of the potential amendment of Rule 5.5, which is what addresses lawyers' ability to engage in multi-jurisdictional practice.
Super. We will revisit that shortly, David. How about Michelle?
Hi, everyone. I should just admit that I bring to this conversation kind of a different perspective. I'm trained as an anthropologist of law, and I work at a medical school. So I'm not law trained. I don't have an MD. But since about 2017, I've been conducting pretty robust mixed methodological research on rural access to justice across northern Minnesota and Wisconsin and Iowa, and now also in Alaska. And that I think it's important to note that these are PL 280 states. And so at least Minnesota and Wisconsin are. And so I work both in tribal and state court jurisdictions. And as part of that research for the past 7 years or so, we've conducted over 450 individual and household legal needs assessments. And I myself have conducted over 400 one-on-one interviews with private practitioners and public interest attorneys and low-income, very diverse rural residents. And so have a very acute kind of grounded sense of what it looks like to navigate these growing legal deserts in kind of diverse rural geographies.
Wonderful. And let me just explain a little bit of why I think I'm here, which is the National Center for State Courts is the secretariat of the Conference of Chief Justices and the Conference of State Court Administrators. And those two bodies have been increasingly looking at the issue of legal deserts because they affect state courts across the country. And just last year, the two conferences hosted a Midwest Summit on legal deserts. And I worked on a session where we did some GIS mapping to help courts in those jurisdictions and their partners better understand the legal opportunities in that jurisdiction, but also more acutely understand where some of those pockets of most vulnerability might be using GIS mapping. And I think Joey and others might have seen those maps and invited me for that reason. So But really excited to be part of this discussion because I think the courts play an important partner role in thinking about legal deserts, just as private attorneys and also community partners. So I think between the three of us, we represent a nice cross-cutting of how to think about legal deserts and how to solve for them. So let's, before we actually get into the solving part, let's define what we mean by legal deserts. So when we talk about this term of art, what is it and how do we measure them? And let's start with Michelle.
Thanks, Danielle. So I think most generally, legal deserts refer to those regions, however, whatever scale we're using, that are just simply experiencing profound attorney shortages. So I can solidly speak to rural spaces where we know that at this point, less than 2% of all solo and small firm practitioners are located in rural communities. And then we have what I'm sure everyone here is very familiar with, the 2020 profile of the legal profession. The ABA officially defined a legal desert as a county with fewer than one lawyer per 1,000 people, which is about 75% lower than the national average, which is 4 lawyers per 1,000. And I know that we're going to have a more robust conversation around measurement and different ways of analyzing these tools, but I will just say that at least in the rural side of things, when it comes to documenting rural attorney shortages, I very strongly suspect that the situation is actually far more dire than it's presented. So we know that state bar associations present the data they've been collecting to the ABA for this profile. And in Minnesota, for instance, we know from our own research that attorney numbers that are being reported include attorneys that may be retired or have actually passed away or are working for state or county government and so can't take on individual cases. So I think it's really critical to say that in rural spaces, I don't think we can fully grasp the magnitude of the issue. And I also think, just very quickly, that when we're talking about rural attorney deserts and recruitment and retention, we have to think a lot about other kinds of deserts as well, right? So in rural spaces, those could be healthcare and mental health care professional deserts, or the fact that there's very limited or absent public transportation, or we have this thing called educational deserts, right? Like there's this whole desert phenomenon, and it's really relevant to this particular professional space. But oftentimes we tend to be so siloed that we don't necessarily see how those things are intertwined.
No, that's fantastic. I just wanted to quickly add, and then curious, David, your thoughts on the definitional question. I think about legal deserts for the same reasons you do, people who want to get a will or talk to a lawyer for any myriad of kind of everyday problems, but beyond that, there's also public defender or indigent defense on top of kind of civil legal problems that we think about, who's going to do that. And then from the court's perspective, there's who's going to be the judge, like at a really practical level. If there are 2 attorneys in a community and they are both like very close to retirement, who is going to fill those constitutional offices too? And so it begets these larger constitutional problems also that a number of court systems have started to develop rural task forces to think about for that reason, in addition to the direct access point. And Ben asked in the chat, and I know Joey sent a link to the GIS maps that we did, but we were looking, Michelle, at very similar kinds of things, trying to understand what we meant not only by attorney population, which is imperfect for all the reasons you mentioned, but also broadband strength, if we're talking about remote, which we'll get into later as remote access as a possibility. If some of these places are also don't have strong Wi-Fi signal, and one of our solutions is remote hearings, then that doesn't work either. And so trying to really understand public transportation, where courthouses are physically located, where legal aid offices are located, where appellate, like all of the structural things, as well as community partners, to try to be creative about solutions. So couldn't agree more with your definition and kind of coda. David, how about you?
It's for me, I think a definition though of it necessarily needs to go beyond just numbers, though, and it's in kind of the context that both Danielle and Michelle have been talking about. You know, we're looking at communities where effectively the needs of the people who live and work there greatly outnumber the amount of lawyers that are available there, because one of the hallmarks that we look at in terms of a client-centric provision of legal services is choice. You know, the choice of who's going to represent you. And if you have a community, you know, the hypothetical where there's two lawyers in town, uh, you know, that doesn't give you a whole lot, especially if you're in a dispute with somebody. And if they lawyer up first, you've got the other person or yourself, right? And so that doesn't really solve that issue and provide somebody necessarily that you trust with. As from the client side, it's sort of the person who you're stuck with. And that's not the concept that we want to have along the way.
And then there's a comment or question in the chat about citizen input included in the studies. And so, Michelle, I know you were thinking about typing an answer. I don't know if it's easier to just answer it or you want to type it. But my kind of initial sense, and then I would be very curious to hear yours, is so my original kind of exposure or thinking about legal deserts in a sustained way came from an initiative called the Justice for All Project, which the National Center was lucky enough to project manage, but was a partnership with a lot of different entities, including the Self-Represented Litigation Network and a number of 14 courts across the country. And a big part of it was mapping ecosystems and getting direct people's input about where they go for help. And what was fascinating to me in places like Alaska, but not exclusively so, was that some of the rural communities had stronger community networks than some urban places. They just had a scarcity of available legal resources. But in terms of thinking about networking and social node analysis, they were stronger than in other places where it was certainly denser and there were more attorneys, but it was harder. So I think getting input is vital to both question assumptions and also understand where you go for potential partnerships. But Michelle, I welcome your feedback too.
I'm a little embarrassed at how like aggressively I'm nodding my head. But yeah, Danielle, I completely agree. And I think to that person's comment, it's absolutely critical, right? And doing research in these rural communities, for me, at first it was quite shocking and stunning and heartbreaking and all of the things you might assume when you realize the different kinds of marginalization that different rural communities experience. And yet those are the spaces in which I think we're finding some of the most innovative and profoundly successful and holistic innovations around access to justice, whether it is something like community justice workers, or in my own individual research, I do a lot of work around active judging and the efforts of tribal and state court judges to provide a really meaningful experience of justice, or thinking about the different kinds of wraparound services and networks that exist across kind of diverse subsets of the community, like stakeholders who you might not immediately expect to work together, and how those things really do provide almost a more proactive approach to attorney shortages, right? Like they're happening in the face of these legal deserts, but they've also been happening for a long time and they're quite successful.
Super. So let's get into it. We've got a working definition of what a legal desert is, and there have been a lot of work in this space. So some potential solutions of how to address legal deserts. And I'd love for in this big chunk that we're going to talk about kind of existing pilots, innovations that work, ethical guidance, and then kind of hopes for the future. But let's start with ethics, David. So can you tell us about the ABA and Rule 5.5 and what we should be thinking about in this space?
Sure, I could fill up more than an hour talking about that, and I promise to all those listening, I won't do that to you. But the concept comes, you know, in terms of addressing 5.5 is this, and for those that aren't familiar with it, I'll just thumbnail sketch along the way. 5.5 is our general rule that says the presumption is you can practice only in the jurisdiction that gives you your license, subject to some limited exceptions for temporary practice in other jurisdictions. I'm not going to go through all the details because that's not important to our discussion here. But in terms of why that's one of the things that we target and how that relates to legal deserts, goes essentially as follows. We start off with the understanding that generally that there's a shortage of amount of lawyers to satisfy everybody's work, regardless of whether you're in a desert or not. California, the state that I practice in, they did a study about 2 years ago, I believe it was, when it was still looking at potentially engaging in some modifications of its rules, perhaps through a sandbox, experiment, and came to the conclusion that even if all of the licensees in the state gave away 50 hours of free work on top of what they were already doing, that the citizens of California would still be underserved. There would still be enough need, for it. And so there are two ways that you address that problem, right? You have either more people that are providing legal services, or you make things more efficient for those who are. And addressing 5.5 really addresses the latter of those things. For those of you that are watching that have taken a bar exam, have completed a moral character application, have sat for the NPRE, know that there's quite a bit that's involved in getting licensed in a particular jurisdiction. In fact, when I began working on this project, I had only been licensed in one jurisdiction. In fact, I still am, but I've become a little bit more sympathetic. In February, I recently sat for the Arizona bar exam, took a test that I hadn't taken in a couple of decades, and on Friday, got confirmation I had passed that and passed my moral character application. So happy story. I can help people that might need help over there, but that's a months-long process. And I'll tell you, I probably put in roughly 400 hours of preparing for this bar exam in order to be ready, because it's been a little while since I've gone to law school. Asking lawyers to do that each time that they may have somebody that goes in it, that's involved in a different jurisdiction, I don't know that that's particularly helpful in protecting the client along the way. The presumption that we are going to provide competent services nonetheless, that we can learn about distinctions along the way, and if we're not, to engage local people to assist us. All of having that in place, potentially this hurdle stands in the way of lawyers efficiently doing that. Not everybody has time to do that. Even jurisdictions where you might be able to practice in by motion, you're going to have a delay in being able to do so. You're spending time engaging that, so that by modifying 5.5 to open up the practice, and for those that are interested and may have seen some of the proposals, there's not a firm draft out yet. The ABA has been working on coming up with a proposal. We spent approximately a year looking at issues that might be triggered by the change in the practice. We are now beginning to work on the drafting of a proposal. So although there have been drafts that have been put out by other groups, including the Association of Professional Responsibility Lawyers and the Ethics Committee of the ABA, came out with an initial draft to consider. There's far from a proposal that's going to be ready to go forward. That probably isn't going to happen until sometime next year. But all of it's aimed at really widening client choice and freeing up lawyer time from trying to address a regulation that's not necessary to protect the public. And it's finding that balance point that's the tough task, right? Because we still do want to protect the people who are using lawyer services, but we want to only get as far as necessary to do so, because the other burdens that we might place on lawyers that are trying to practice gets in the way of them being able to help out other people.
Wonderful. Well, let's put a pin in kind of how to deploy existing lawyers more strategically, because I think we'll come back to that with incubators and other things. but not all legal needs require the same solution. And it's exciting to think about the diversity of solutions that we can address. And one of those bright spots is allied legal professionals. And Michelle, we know you've been involved in community justice workers. Can you help us understand the work that's been done in your work, and what we can learn from it?
Yeah, I'm very happy to talk about that. So I'm presently the PI on a National Science Foundation Civic Innovation Grant. There are 2 stages to this grant, and we're currently in the 2nd stage, which was for $1 million. So we had some pretty incredible support to advance this model, but I'm just sharing that in the interest of full disclosure that I'm personally involved from this, but as a researcher, so I take no credit for the amazing work that's being done. But just in short, like so many rural and remote areas, Alaska has faced a really profound attorney shortage for a long time. And in addition to that, I think most folks here know Alaska has no law school. And so many of the attorneys who would come in were from out of state. And there were some real, I would say, ethical issues around these attorneys who, however, really wonderfully intentioned, were practicing in different kinds of villages, many of them Alaska Native villages, without a strong understanding of the different sorts of values and expectations and even languages that community members might hold. And so about 3 years ago, the executive director of Alaska Legal Services Corporation kind of outright acknowledged that there would never be enough attorneys to meaningfully and in a culturally representative and sensitive way address all of those diverse and urgent civil justice needs of Alaskans. And so what happened was they essentially modeled this community justice worker program after an existing community health aide and practitioner program, which had originated in Alaska and has been there for about 55 years and is phenomenally successful. And what this program does is it trains individuals who are themselves embedded within Alaska Native and other communities in Alaska to provide different kinds of medical care. And so essentially what's been happening is the folks at Alaska Legal Services Corporation partnered with the Alaska Native Tribal Health Consortium, as well as the Alaska Pacific University, to develop a new model that trains individuals who are kind of like that CHAPS model, already embedded in these nonprofit and governmental organizations. So they're known, they're trusted, they're often culturally and linguistically representative. They might be working at domestic violence shelters or in a realty office or maybe at a tribal health care center. And these individuals take asynchronous models and also go through some pretty serious mentorship training as well to develop training and expertise in set practice areas. And so right now there are 5 finalized practice areas. They're accessing SNAP and unemployment benefits, DV civil protective orders, wills, evictions, and Indian child welfare. And right now they're additionally developing 2 new topics, training for 2 new topics in ethics and procedure, as well as credentialing standards for 3 different skill levels. And I think it's really important, especially with this audience, to highlight that community justice workers are always under the supervision of Alaska Legal Services Corporation attorneys. And so it's really significant about this particular model, and the whole reason why I felt comfortable coming on as a researcher, because I'm quite skeptical, right? Like all of my data make me, I think, a little bit cynical about certainly sort of silver bullet initiatives. But what is so beautiful and relevant and made me an early supporter of the model is that it directly appeals to the expectations and values of community members themselves in terms of it being accessible, it's trusted, it's timely. This is service provision that really addresses those legal deserts in an accountable and ethical way. And amazingly and wonderfully, the state would agree to that. So in 2023, as I'm sure many of you know, with the support of the Alaska State Bar Association, the Alaska Supreme Court passed a UPL waiver for the unauthorized practice of law. So CJWs are now authorized to represent clients in state and tribal courts. And I think it's worth noting that at this point, there are more community justice workers practicing in Alaska than there are allied professionals altogether working in the lower 48 states. So this model has just taken off. It's been quite successful across the very large state of Alaska. And now with federal disaster relief funding, it's being rolled out in 5 other states. And there are still more states that are taking very close note of this and thinking about passing similar waivers.
And just quickly, Michelle, Chris asks in the chat who credentials the justice workers. And so I just want to make sure I've heard it right. So to my knowledge, the question is, when do you regulate these workers? And in the Alaska context, they've deputized Alaska Legal Services to provide the training and credentialing of the community justice workers. They don't then apply to the bar directly. Is that correct?
I believe that's correct. And right now, as part of this research process, we're working through the credentialing procedures and processes because it's a really interesting dance. Again, this is not where my expertise lies. I just want to make that abundantly clear. But there's a real concern also about over-credentialing, right? Like this is intended to do a lot of different things, including workforce development. And so the barriers to entry need to be low. And I think that's a really important thing when it comes to honoring and advancing community members who have very relevant expertise and who are uniquely poised to develop this new kind of language and skill set, while also still obviously needing to work within professional expectations and bounds. So please check back in about a year, because I'm sure we'll have more to say.
Wonderful. And I know the Department of Justice is hosting a webinar, perhaps even in 2 weeks, looking with the Legal Aid Interagency Roundtable about the use of kind of allied professionals in a lot of administrative functions. So if you're interested in this conversation, perhaps there's a lot more that you can continue to learn and grow in other places. So I want to pivot a little bit and talk about, we can talk about community partners, we can talk about available lawyers, and we can also think about ways that we can deploy those limited lawyers more strategically and efficiently. And I just wanted to give a couple of examples of jurisdictions that are thinking about this. So the New York Bar had a study last year in 2023 that was looking at kind of remote or rural access. And they coined a term, which perhaps has been a term for a long time, but it was novel to me, which is looking at windshield time, how long lawyers are traveling in between jurisdictions to go serve clients. And it wasn't uncommon in rural communities for a lawyer to spend hours on the road in windshield time for what can often be a really ministerial hearing. So it could be a 5-minute hearing that knocks out an entire day of travel back and forth. And so the idea of using remote hearings, especially in these status or more perfunctory hearings, as a tool. This, of course, assumes you have Wi-Fi and broadband and all the things that we're also talking about, which are important to measure. So they are not itself a monolith, but it seems important to think about remote hearings as a legal desert potential strategy. And one interesting example, which I think hopefully Joey will put in the chat, is the First Circuit in Illinois, thanks to Sarah Song from the Administrative Office of Illinois Courts and Diane Goffinet from Land of Lincoln Legal Assistance Foundation, did an interesting study, like just back of the envelope, what happened to the legal aid lawyers in that circuit when they started to use remote hearings. How much time were they saving from the windshield time? And what were they doing as a result of that? And so looking even at just very modest count, they were able to take many more domestic violence cases than they would have otherwise. They were able to spend longer with clients as a result of the ability to use remote hearings. And so I would encourage anybody who's interested both to take a look at the study, because it was both relatively modest, pretty inexpensive to do, and I think a useful tool when advocating with courts about what is possible when courts consider the idea of keeping remote hearings, especially in more high volume case types where it can enable similar levels of uses of attorneys, but just saving all the windshield time. And also the lack of public transportation for the clients themselves, and perhaps the need for childcare, taking unpaid time off from work, et cetera. There are myriad other benefits that the Illinois study doesn't even begin to quantify, which could be very meaningful and important. And then, sorry, you get my little monologue for a little while. David mentioned, and kind of Michelle too, to some degree, kind of, there's the issue of how we educate and admit lawyers to practice law. And I wanted to mention and encourage people to provide feedback to us. The Conference of Chief Justices and Conference of State Court Administrators last year passed a new reform, which is called CLEAR, the Committee on Legal Education and Admissions Reform. It's being chaired by Chief Justice Gordon MacDonald from the New Hampshire Supreme Court and Chief Justice Shannon Bacon from New Mexico. But it is really looking at the state of legal education and admissions because the state Supreme Courts are the regulators of who can practice law. And so they're looking at how people are admitted to practice law in various states so that perhaps in the future, people like David don't have to spend 400 hours necessarily taking a new bar exam. But also from the beginning, what is both necessary to prove competency to practice law? What does practice readiness mean? And how can we ensure that lawyers who graduate, if they are to work in rural communities, can hang a shingle and competently represent people who have legal needs once they've graduated? And then how do we also separately but relatedly encourage people to go into public interest, especially in those places? And that can mean everything from indigent defense to civil legal services to appointed counsel, which happens all over the country. And the project is in its infancy, but is very strongly encouraging of public comment and feedback. And if you Google, I apologize, I didn't put the link in the chat, but if you Google National Center for State Courts and CLEAR, as it is spelled, you'll get to the website and there's a specific online form. So would welcome, you can see who's involved and what's going on. And relatedly, another mode that we can think about, right? There's like education as a whole, and then there's the issue of debt when you come out of school and wanting to work in a rural community. And I wanted to highlight a state that's done something really innovative, which is South Dakota. The South Dakota Supreme Court worked with the legislature about 10 years ago to pass a loan forgiveness repayment program for attorneys coming out of the University of South Dakota who are going to practice in rural communities. And it is a small, modest way to incentivize people who are already interested in serving in rural communities to do so without a financial hardship of paying back some of their loans. So there's a lot of room in that space for similar kinds of programs in complement to public service loan forgiveness and other things. But I wanted to mention that. Okay, end of my rant. Although I hope we will get into a conversation in a minute about all of this stew of interesting things. But before we do that, the last kind of big innovation that we bracketed when we talked to plan this conversation was the issue of legal incubators and to try to support and encourage, especially young lawyers, to serve modest means clients. And David, I was wondering if you could kick us off kind of what you think about the idea of legal incubators as a strategy.
Sure. And before I do that, maybe we'll get to this in our conversation, but when we talk about education, it's so often when we look at what's available to people along the way, I'm a big believer, and it starts at who we admit to law schools. And I think part of the solution to this is looking at this already in rural areas that are going to be available, because there are two reasons usually why people move to a place. One, because there's some sort of economic incentive to do so. If they're going to get clients there. The second, though, is they like the environment, and somebody who's used to it and appreciates living in that type of environment my theory, whether it's supported or not, is that you're probably going to be more likely to return to that rural area if you're used to it and that feels like home than if you've grown up in a suburban or city environment. And so part of this is understanding who it is that we're admitting to law schools along the way. So I don't know that we can control that because we can't tell law schools who to admit, not to admit, but certainly I think that's one of the things to target to address this kind of issue. But to the question posed to me, because I think it's important for us to eventually get that right. Legal incubators, for those that aren't familiar with that, our systems are largely, the ones I've seen have largely been associated with law schools. I'm aware of a couple that are associated not with law schools, but are essentially the old ways that lawyers were trained. Before the report that came out 100 years ago in the ABA that changed the way that lawyers were admitted. There was effectively an apprenticeship system in most of the states. And that's in essence what incubators do. You have trained mentors that are available that have assets that widely vary, depend on the incubator program on what will be provided. But those are designed to help newer lawyers skills that are involved with the just the practice of law, but the business of law. That's you don't necessarily learn in law school along the way. And having somebody watch over you and help you, and the incubators that I've seen have, I think, universally required some type of pro bono or low bono assistance as part of their efforts. But it's training these newer lawyers how to run a business. And why that matters in the context of legal deserts, I don't think that you're going to see a whole lot of big law moving out, in putting an office in the country. It's largely going to be the solo and small firms that you will see developing over there. And so it's these types of programs that give people the ability to set up their own shop, to understand how to run things, to make sure that they can handle not just all of their clients, but the business aspects. Because again, if you're worried about handling the business aspects, that's taking your focus away from how you're helping your clients. Just like you're wondering how to handle regulations, it's taking time away from clients. So these incubators solve at least that portion of the problem, or at least try to address.
Yeah, no, that's really wonderful. All right, so we've talked about lawyers, we've talked about community justice workers, we've talked about legal education, about like outreach and admissions reform. We've talked about engaging with courts strategically. So now what? Like, here are some questions, and I'm curious for any of your or kind of organic reactions, right? So are there more examples of how this is working that we should showcase? How do we measure success of what these innovative things are happening? Like, where should we go from here? I'm giving us a jump ball.
Few thoughts. Could I jump in very quickly?
Please.
Before a small person comes in with questions, who knows? Two things I wanted to mention. I think it's really critical to not overlook different kinds of tribal jurisdictions and tribal lay advocacy programs and training programs, because those have been around for a relatively long time and have themselves become really, really distinct models for pathways to practice. And one thing that I see quite a bit in my own geography of the upper Midwest is that a lot of folks who go through tribal lay advocacy training then do something like Mitchell Hamlin's hybrid JD, because these are individuals who are already quite well versed in different dimensions of the law, but who might already have families and other kinds of employment. And so that's been a really successful model. I also wanted to briefly highlight Nebraska's Rural Law Opportunities Program, RLOP. I mentioned in the chat already that Project Rural Practice, like you mentioned, Danielle, it's been a relatively long time. And so we have like quite a bit of good evaluative data around it. And both its successes and its limitations. And one thing that I think kind of speaks to what David is talking about in terms of that the best people or the folks who are maybe most well suited or committed to practice in rural communities are arguably rural people themselves. And RLOP really taps into that idea by recruiting at the high school level. And so if there are individuals in high school who express some sort of interest in the law and in potentially returning to their communities to practice, they receive scholarships that helps fund their undergraduate education. And they're in this unique position where they're invited to attend different kinds of law school events. They're invited to classes, seminars, networking events, just to really get a strong sense of what law school might be like, and also what practice might be like. And then between their junior and senior years of college, they have an opportunity to participate in different rural Nebraska internships. And what I really love about this model is that it's a little bit different from the Project Rural Practice model in that it's differently supported and incentivized. So there's very little risk for students if they change their minds, right? Like they don't necessarily have to go to law school. They don't necessarily have to commit to practice for a certain number of years, right? They can just kind of dip their toes in the water, get very familiar, get very socialized in these different kinds of professional spaces, and then make an educated decision, which I think is beautiful. Speaking very personally, I was a first generation college graduate, and I didn't even think that law school would be an opportunity for me. And it's only now at age 40 where I'm like, I would love to go to law school. Like maybe I should look into that. But the other little piece that I think is important to mention here is that I happen to know that different folks at Creighton University School of Law, which is based in Omaha, which is an urban community, have reached out to the good people at RLOP just to say, like, we could do something similar here to help address attorney shortages in more diverse urban spaces. How can there be kind of a cross-pollination here? And I love that. Like, I think that's a really tangible and replicable model for recruiting and really supporting and training potential JDs to practice in those underserved areas.
Michelle, I love it. At the kind of Midwest Legal Desert Summit that I mentioned at the top, there was a whole panel with including people from the University of Nebraska, but particularly looking at veterinary school programs and how veterinary education has masterfully figured out ways to get remote or rural practice for veterinary needs in a lot of underserved communities, starting with high school and college kind of pipeline development and then supporting people to go into rural veterinary practice. So I think this is a model where we really can learn from other sectors. And there were a number of states that had provided, like the South Dakota loan repayment example, kind of financial incentives in addition to kind of support and training to help people with kind of supporting the decision to go into a legal career. I just want to add one other thing, which this is not my story. This is Justin Faulkner's, who's the state court administrator in Indiana, but I think it's a really instructive one. Justin is a peach of a human being if you don't know him. And in addition to his very busy day job of being the state court administrator, he also teaches legal writing at one of Indiana's law schools. And one of his students was the mayor of a small town in Indiana who drove 2.5 hours each way to go to class at night. And we should, and so this experience among a myriad others informed his desire to promote online legal education. And so the Indiana Supreme Court has been looking at universities like Purdue Global as a potential strategy for how to meet the needs of people so that, David is right. People who live in rural communities are far more likely to then serve in the communities that they live in than necessarily recruiting someone who is from a different community to move to an urban or rural community. And not that it can't be done, but it's far more likely that they're already like networked and supported. And this particular mayor was going to law school because he felt like his community needed more lawyers, and he was doing it for all of the reasons we would want him to, and institutionally, it was still really challenging. So anyway, it begets creativity. So delighted to hear about some of the models. Yeah. What else should we talk about?
So there were a couple of good questions in chat that I not that I'm not paying attention to you, but I'm reading what our audience is saying too.
No, do it.
One of them was bringing up, geez, isn't it this a problem because, so often in these legal deserts, they're modest means types of communities. And, it just triggers a thought in my mind. It sort of relates to one of my favorite expressions, which is, sometimes the people who are hardest to love are the ones who need it most. Well, it's in these rural communities, it's sometimes, the people who can least afford legal services are the ones who need it most. And, it's, I think that's the biggest challenge outside of the environmental, right? It's that economic aspect. It's how do you incentivize somebody to say, you know what, I see the people that I went to law school with, and they are able to practice and be, and receive compensation at a different level than I am. I'm going to be the one that raises my hand and say, you know what, I'm going to do the same work that you're doing, and I'm going to be paid less for it because the people who I'm doing it for, need it more. I think that's a tough ask along the way, and that may circle back into the, how can we incentivize, people that, yep, that they've got a heart of gold, but they also, have those huge loans to pay back. They've got families that they want to support, and that matters to them. The South Dakota model, I agree, is a great one to get to that, but that's a realistic barrier to addressing this.
So Isabel Shapiro in the chat challenged us with a big question. So let's, we got a few minutes. And it's curious if we can think about the demand side for legal services and whether there are promising examples of access to justice so that we can solve the problem without needing a lawyer and going to court, essentially. And I'm curious, kind of both of your thoughts. Let me start with mine, and then would love your reactions. One is courts that provide good self-help resources to people. Lawyers or community justice workers, regardless, are like a scarce resource. And so if we think about available legal needs, we should be using, especially the scarcest ones being the lawyers, for the things that most need a lawyer. So if a court is providing really clear self-help information and forms and very clear about what processes there are, you can save the legal needs for the more complicated, more nuanced situations, and to use community justice workers for what they are appropriately trained for. I know that's not the big swing, Isabel, that I think you're asking for. The one big swing that I'll mention, and then I'd love to pause, is my colleague Samira Nazem leads the National Center has an eviction diversion initiative, which is working in rural, urban, and suburban jurisdictions across the country. And it's trying to meet the needs of landlords and tenants. It is court connected because cases are typically filed, although some places like Alaska are doing interventions pre-filing. But it is trying to think about what are the needs of the people who come into eviction court, and how can we solve them not only for the court matter, but long term. And some of the things we're finding out is, in many instances, the tenant may no longer want to live in that residence or understands that they need to move, but it's having space to have a dignified exit, having wraparound community services to figure out where an appropriate place to go is, so to prevent homelessness, trying to not get an eviction on a record so that they can't get a future apartment. I mean, there are lots of different potential considerations. And I think the work Samira is doing is a really wonderful example of trying to understand how a community can better meet the needs of people, whereas court is a connecting resource, but not necessarily alone going to solve the problem. So that's my big swing that I will share with you, Isabel, but I'm curious, David and Michelle, if you have others.
Well, I think one of the challenges with the thought of using a court-based help is, from the regulatory side is this. that so often jurisdictions look at the practice of law. You know, it's fine to provide, here's a stack of forms, but telling you which form to fill out or how to fill it out, most people define it as engaging in the practice of law. And of course, we don't want our courts, who are supposed to be filled with um, employees that are neutral as to the people who enter the hallways and serve them all, engaging in that. And I think that there is a practical effect of what Danielle's offered, and perhaps it's adjusting the regulations to allow that, because there comes a point where you need to allow some non-lawyers to help out in certain activities that are traditionally done by lawyers. And it's that there's another question, how do you see the roles of paralegals rising to help fill the gap? And it's that's part of it, and it's perhaps borrowing from some of the models. I know Washington tried a licensing program for legal technicians that failed largely because of the number of people involved and the cost in maintaining the program. It didn't make sense along the way. But perhaps in looking at, here are particular practice areas, here are particular geographic areas that make sense. That's the way to fill it in with people that might be neutral to the process, or might not have to be neutral to the process and can still help out. But it's again, it's the same problems that you have with lawyers. How do you train somebody to be a paralegal and say, you know what, and I want you to serve this rural community, and it's making it attractive to them. One of the odd things in California that we've seen a lot of is the people who are going to practice in rural communities, who are lawyers, are usually going out there not as new lawyers, but as, hey, I'm moving out there and eventually I'm going to retire there. So there are a lot of, here's a short-term fix, in that last 5 to 10 years of my practice, but we're not getting folks going there for the majority of the time. And it's figuring out, how do we make that more attractive so that people are choosing to go.
That's such a good point, David. I hadn't really thought about that. I want to weigh in here, and I hope that in offering a little bit of my own data that might touch on the question about restorative justice in the Q&A. I think that in terms of kind of getting at the upstream dimensions of having justice issues, I want to echo Danielle and just saying those wraparound supports and those service providers who aren't necessarily law trained or even work in the legal sphere are absolutely critical. So in my own research, I've had the great opportunity to work with a team of folks who just sort of casually identifies like a no wrong door initiative, and they represent different communities on the Iron Range, including some sovereign nations, and they meet once a week. Some of the folks on this team have identified as being just one paycheck ahead of the people they themselves are serving, right? These are largely underpaid, but overly committed individuals who are pooling resources and making sure they're addressing the needs of whatever individual or family has come into one of their offices collectively. And I think that kind of effort really keeps people out of the court system. The other thing I wanted to mention is that I have the really amazing good fortune to work in a lot of different healing to wellness courts, and actually and working in a couple of housing stability courts, which are quite interesting in tribal court jurisdictions. And just want to very briefly share that in the housing stability court, not only are there folks who are representing like treatment or child welfare or mental health, but there are also a lot of peer supports. And one individual I spoke with just last week, and I thought this was so beautifully phrased. She said, we talk a lot about doulas, right? Like these people who kind of are there to help with the birth of a baby and provide different kinds of supports. And she said, but what we really need is something like a housing doula, right? Someone who can come in and walk beside someone and say, you know what? Like, here's how we can keep this house clean. Because particularly in the tribal context, there's a lot of intergenerational trauma. There are grandparents and aunties who may have gone to boarding schools and didn't necessarily learn these things, right? And so it's just like, how can we ensure that people can be stably housed and maintain housing in an incredibly empathetic and holistic way, right? I think we tend to just sort of compartmentalize, like the social worker does this and the lawyer does this and the judge does this and the treatment counselor does this, and instead it's like it's everything, right? And we need to be so uniquely attuned to individual needs. And I think that restorative justice space has incredible success, particularly when we measure and understand success in a way that's meaningful to the people at the center of it, not just our own sort of measures and outcomes.
That is lovely. We have like 2 minutes before we have to give the keys back to Joey. So in these last 2 minutes, how about like final words from each of you as to kind of legal deserts and what the people watching should do about it?
I'll let Michelle go first since I wasn't ready for the quiz.
You know, this isn't a cop out. I think that the answers largely do exist in different kinds of communities, and in like those informal networks and in community members who are deeply paying attention to the needs of their neighbors. And those could be attorneys, they could be tribal and state court judges, they could be educators, elders, right? I think we would just do very well to listen and respond accordingly. And I will just very briefly say that it's such an honor to be a part of this conversation, because I see the work that you both are doing, and I'm sure our audience is deeply invested in these issues as well. So it's a great crowd to be a part of.
Well, here. David, if it's all right with you, I think we're at time. I think let's let Michelle have had the last word. That was lovely. Thank you to both of you for this great discussion. And Joey, we're going to hand it back to you.
Thank you all so much for an excellent panel, and thank you for our audience for having such an engaged Q&A session. We could barely keep up, so thank you for being so engaged and being invested. A big thank you again to Danielle, Michelle, and David for their contribution to this event. As a reminder, the views of our panelists may not represent those of the ABA and were not approved by the Board of Governors or the House of Delegates. Additionally, just a reminder that these events, our Redesigning Legal events, are always available on demand on both the ISLES and the ABA Center for Innovation website, typically within about a week of our event, potentially sooner. And of course, we'll email our registrants when that is available. Again, we thank you all for your contributions today. This is a really engaging conversation. I think one that's ending on a somewhat optimistic tone, which is always a good thing when we're talking about expanding access to legal services. So thank you for everyone today. And for those of you attending, we will see you at our next event.